A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. I am so glad you've joined us on the program today. We're going to be talking with Dave Kopel, Research Director at the Independence Institute, here in just a minute or two, about a very important case that the Supreme Court is now weighing whether or not to accept a challenge to Maryland's ban on so-called assault weapons, a ban, by the way, that has been upheld by the Fourth Circuit Court of Appeals on what I think is flimsy, doesn't even begin to describe it. In essence, the Fourth Circuit Court of Appeals ruled that Maryland's ban on the most commonly sold rifle in the country today is perfectly fine, even though we have a constitutional right to keep and bear arms, because according to the Fourth Circuit, AR-15s and other semi-automatic rifles are like machine guns and therefore fall outside of the scope of the Second Amendment. Yeah. Again, we're going to talk about this with Dave Kopel in just a moment. Before we do, however, with the political pressure of the left and the woke mob that is the Democrat Party these days, our society is in danger of becoming controlled by the cancel culture elites. Since when have the founders of our Constitution or the creators of the American flag or figures like Dr. Seuss or anything else you can dream of become anti-American? There's never been a better time in our nation's history to stand up against this woke mob and fight back, and you can do just that with this exclusive offer that I'm giving my listeners and viewers for a limited time only. Now is your chance to win a signed picture by President Trump himself. That's right. Not only will you be taking a stand against the radical left, but you'll be entering to win a piece of history. All you have to do is text the word Trump to 55404 today to enter. That's TRUMP to 55404, and you can join the millions of Americans in standing up for President Trump and canceling the radical left once and for all. Paid for by the National Republican Senatorial Committee. All right, so let's get to our conversation with Dave Kopel. I'm really excited about this. This has been a story. We've talked about this case a couple of times before, but the reason why I wanted to get Dave on the show to talk about it is because he is the author of an amicus brief that was just filed with the U.S. Supreme Court. In fact, when we were talking with Alan Gottlieb of the Second Amendment Foundation about this case not long ago, Alan brought up, he's calling it the scholar's brief. And it's not just Dave who is a part of this. There are a number of other Second Amendment scholars who have laid out their legal rationale for the court to hear this issue, even though the Supreme Court turned away a challenge to Maryland's assault weapons ban just a few years ago. Let's delve into this with Dave Kopel, Research Director at the Independence Institute. Take a look and a listen. Dave, it's so good talking to you. Thanks so much for joining us here on the program today.
I am happy to be here and happy you are continuing in many more years of radio and broadcast excellence.
Well, thank you very much for that. And I'm still happy that you are out there contributing to the Second Amendment scholarship that we so desperately need. And as a matter of fact, I want to talk specifically about this amicus brief that you authored. We talked with Alan Gottlieb of the Second Amendment Foundation last week about this case challenging Maryland's ban on quote-unquote assault weapons. And not only do we have, 25 attorneys general from around the country urging the Supreme Court to hear this case and to hear this challenge, but you are the author of what Alan is calling the scholar's brief. And we've got a lot of heavy hitters in terms of Second Amendment historians and legal scholars, including yourself, who are also making the case that the court should grant cert here. What is the argument that you lay out in your brief, Dave?
Well, since, as you say, it's a brief of law professors and also of think tanks, the Independence Institute, where I work, the John Locke Foundation in North Carolina, the Cato Institute, and we were also joined by the Mountain States Legal Foundation with its which has a special project that works on right to arms issues. But the main thing, as you say, is we a dozen law professors. And so being law professors, we tried to focus on the legal doctrinal issues and on legal history. So the brief begins by looking at the decisions in the lower federal courts, the circuit courts of appeal, that upheld the Maryland ban and also similar ones in other circuits, and point out how they are inconsistent with, not just with Heller, because the petitioners do a good job on that, but inconsistent with Supreme Court precedent more broadly, and also internally inconsistent.
Okay, now, and I want to ask you to explain that a little bit, because this case is challenging Maryland's law, but
Yeah,
you all reference more than just the Fourth Circuit, the controlling opinion from
right.
the Fourth Circuit, because we've seen other really, I think, egregiously bad opinions from like the
Yes.
Second Circuit Court of Appeals.
Yeah.
So what are some of these issues? Because obviously the argument that Brian Frost is going to make Maryland's Attorney General is that, look, this has already been litigated. The Supreme Court had the opportunity to take a case a few years ago. They passed on this case, so this is moot. It's settled. It's settled law. Why do you think the court should take up this case, and how are these lower court rulings violating existing precedent?
Well, so let's take a look at the Maryland precedent, which is called Colby versus Hogan, which was decided a few years by the Fourth Circuit en banc after a 2-1, which reversed a 2-1 panel decision that said the Maryland ban should be sent back to the district court and reviewed under strict scrutiny. And then the court, the full Fourth Circuit, took that case en banc and reversed and said, no, you don't even really have a Second Amendment issue here, this gun ban, because the Heller case said you can ban dangerous and unusual weapons, which is true. And they couldn't really say these are unusual, because they're not. They're extremely common. I mean, the AR platforms probably is the most common rifle in American history. But they looked at another phrase in Heller that said it's okay to ban, the way the Fourth Circuit read it, you can ban the M16 fully automatic assault rifle. And from the Fourth Circuit extrapolates from this and says you can ban anything that's like a military gun, a gun that's most useful in military service. And we point out the absurdity of that, at least in terms of the original meaning of the Second Amendment, because the guns that people brought to militia service in the Revolution and thereafter in the early Republic were the ancestors, in a sense, of the AR-15, which, some people call it a sport utility rifle because it's good for a lot of things. It's a good hunting gun for game up to a certain size. Not you wouldn't go moose hunting with it, but for deer, it's a good hunting gun. It's a good personal defense gun for self-defense in the home, and it is a good gun for community defense, as in militia service. And those are the kinds of guns that the people had in the early Republic and the colonial period. These hybrid guns, they weren't exactly muskets and they weren't exactly fowling guns. They were this hybrid that started getting created in New Netherland with the Dutch Fowler as a bird hunting gun, as it got modified by gunsmiths in America for American conditions. And that leads then a century later to what's called the semi-military gun, these hybrids, where you have a gun that it's not really the best infantry gun, but it's a good militia gun. It's a good hunting gun. It's a good self-defense gun, and that was the classic firearm that Americans brought to militia service. So hybrid long guns are exactly at the core of the original meaning of the Second Amendment. And likewise, the Seventh Circuit had said, well, it made up its own completely novel test. But part of that was, well, is this like a gun that was in existence in 1791? Well, these are semi-autos, so they're repeating guns. And the answer is clearly yes, because the Lorenzoni model started out as a pistol, was 150 years old by the time the Second Amendment was ratified. And the Lorenzoni, you can guess the guy who invented it was Italian, but it was something that was widely copied all over the world and even made in the United States. So it was not the most common gun, because repeating arms were quite expensive at the time, because they needed more labor to do the intricate parts fitting. but again, we have repeating arms were already on the table. They were there, and then the probably most famous one in the early republic was the Girondoni air rifle, which it's not a powder gun, but it was a powerful gun. You could take an elk with it at 100 yards, and it shot 21 or had and you could fire it as fast as you could pull the trigger, basically. So it was, in that regard, it was similar to a semi-auto. Lewis and Clark carried it on their expedition and used it to pretty good effect, in the sense that, I mean, they were always going to be a smaller party surrounded by much larger groups of potentially hostile people. And usually they'd meet some folks and say, hey, check out our new gun, and they'd fire off a few consecutive shots with it, astonishing the Indians, who were used to guns but had never seen something like this before. And that helped protect the deterrent effect of that, helped protect the expedition the whole way. So those are the kinds of things we talk about in the brief, about the history of arms and legal history.
I want to go back to something you said about the Seventh Circuit, where they talked about this basically being an unusual gun. Well, they didn't have these types of guns in existence at the time of the founding. Correct me if I'm wrong, but hasn't the Supreme Court said that doesn't matter? I mean, in the Catano decision, or the Catano guidance that came down, that was dealing with stun guns, and the court said arms that were not around in 1791 are not automatically precluded from Second Amendment protections, right?
Yes, and of course Heller said that too. And as Heller pointed out, the First Amendment protects forms of communication like video chats that weren't in existence in 1791, and the Fourth Amendment protects against types of searches, such as flyover thermal imaging to look inside a home, that didn't exist in 1791 either. So of course the Constitution has eternal principles, but those principles keep up with the times as technology changes. So yeah, the Seventh Circuit is it was Judge Easterbrook who is, I think, strongly of the opinion that he's much smarter than all those pea brains on the Supreme Court. So he decided to write his own theory of what the Second Amendment's about.
Okay. All right. And so as far as the chances of the court taking this case, obviously, when, in any given case, the odds are against the court taking a case just because of the sheer number of cases that they hear. I do think it's interesting that they specifically asked Maryland's Attorney General to respond to this lawsuit. But are there any particular challenges, Dave, with the fact that Colby versus Hogan was not taken up by the Supreme Court, and now we've got this new challenge? Is there anything stopping the Supreme Court from saying, yeah, we know that we passed on it a few years ago, but we're going to take another look at this issue now?
Nothing stops them from doing that. So as you say, when this petition for certiorari was filed by the plaintiffs in December, Maryland Attorney General Brian Frosh had the opportunity, of course, to file a response, and waived that. And that's back to part of the strategy that makes sense from his point of view. You mentioned earlier in the show that, this is hardly important. We don't even want to bother to write a response brief. It's so obvious that there's nothing, nothing to see here, Supreme Court.
Right.
Well, the Supreme Court, and any one justice can do this, and you don't know who it does, but or it could have been more justices. But anyway, in mid-January, they called for a response, which is, in essence, is saying, hey, Maryland Attorney General, we actually would like to hear your opinion, what you think about this case. And that's a important and strong signal that the court is at least seriously interested in the case. The data show that when you have a normal party, like not a prisoner who's, say, proceeding pro se and just representing himself, but when you have a party who's represented by counsel and the court does a CFR, call for response, about 10% of those ultimately result in a cert grant. So 10% is 10 times better than the odds of a cert grant in general, which is about 1%. And the fact that the Supreme Court is well aware that when a denial of certiorari, like the cert petition that came from Colby v. Hogan several years ago, is not a decision on the merits. It's just a decision. We don't want to take this case now. It certainly doesn't preclude the court from taking it up later. Just like in, most famously, in the early 1980s, the city of Morton Grove, Illinois, banned handguns. The Seventh Circuit upheld that in a 2-1 split decision. And then the plaintiffs petitioned for certiorari, and it was 1983. The Supreme Court denied certiorari. And then later, a different Supreme Court with different personnel decided they were interested in the issue, and they granted certiorari in 2007 in the Heller case. So, and we have a different court now than we did when cert was denied, and particularly in that the enigmatic Justice Kennedy, who nobody was really sure what he was going to do, has retired, and Judge Kavanaugh, when he was on the D.C. Circuit, wrote a dissent in Heller too, a case challenging D.C.'s post-Heller laws, and part of that he said, no, clearly reading Heller, you just can't ban common arms. You can regulate them, no problem with that, but you can't absolutely prohibit them. So that's one big step, and then Justice Barrett hasn't written, and when she was judge or professor at Notre Dame, hasn't written on this issue anything judicially on this issue, but I think it can be suspected she's at least more broadly open to Second Amendment arguments than her predecessor, Justice Ginsburg, was.
I think that is fair to say. Yeah, absolutely. And I'm going to ask you to read the tea leaves just a little bit if you can here, because we are obviously waiting the Supreme Court's decision in Bruin, the case dealing with the New York right to carry laws. That we're all anticipating is going to come out at some point in June. What do you think the court is going to do, not only with this current challenge to the Maryland gun ban, but we've got New Jersey's magazine ban that's still before the court. There are about almost a half dozen cases, I think, right now that the court has just sort of set aside. Do you think it's most likely that that the court will kind of keep all of these cases in a holding pattern until after the Bruin decision comes out, and then they'll start to figure out, okay, we're going to kick some of these down to lower courts. Maybe we'll deny cert, but we're going to grant cert over here?
I think that's based on past behavior. That's a very reasonable possibility. There's actually in a few weeks, there's going to be another cert petition filed in a case called Duncan versus Bonta, which is about the Ninth Circuit en banc decision recently that upheld California's confiscation law for magazines over 10 rounds. So what we've seen so far from the court this term is some Second Amendment related cert petitions have just been denied. They go into the conference, court denies them, and that's it. Others seem to have been put on hold. And this, probably the best scenario, realistic scenario, is this cert petition gets into that category. And then whenever the court makes its decision in the New York State right to carry case, which could be in May, but as you said, it's a blockbuster case, and those tend to come out in June and usually towards the end of June, that either on the day that the court issues its decision in that case, that day or maybe within a couple days thereafter, then they will give us the results for all these pending Second Amendment cert petitions, which, as you say, would likely be to deny most of them, but perhaps to grant cert in one or two.
Yeah. Okay. And maybe remand some of these cases back down to lower courts with guidance based on what comes out of the Bruin decision. I guess that's a possibility as well in some of these cases. Anyway, Dave, listen, I cannot thank you enough for joining us on the program and kind of getting into some detail about what this particular brief covers. I am cautiously optimistic that the court is going to take this case. I'm keeping my fingers crossed anyway. I think they need to, because as you and others have pointed out, I mean, the lower courts have just abused the language of Heller and McDonald to try to uphold these gun bans in the clear face, of what these opinions have said and what the plain text of the Second Amendment says. So I am Like I said, I'm cautiously optimistic we're going to be moving forward here. I thank you for everything that you're doing to keep our Second Amendment rights strong and secure. And I look forward to having you back on the program again before long. It's been way too long.
I'm looking forward to getting back in it, and I've always had a great time coming on your programming because you are a knowledgeable host. The host with the most.
Well, I appreciate that. I'm only knowledgeable because I talk to people who are smarter than myself, like you, and that's what makes me educated on this issue. Dave Kopel, thank you so much, sir. Look forward to doing this again very soon.
Sounds great. Thanks.
I do appreciate Dave joining us on the program. It's great talking with him, and I look forward to having him back again very soon. Right now, let's turn our attention to today's Armed Citizen story, our good deed of the day, our recidivist report as well. In fact, let's start there with a case out of Detroit. Oh, Cameron. I hate it when people named Cameron get in trouble with the law, although my name is not spelled C-A-M-R-O-N. I've got an E in there as well. But Cameron Trimble facing a charge of being a felon in possession of a firearm. And unfortunately for Cameron, police have all kinds of evidence because he posted pictures of him holding a gun on Instagram while he was actively on probation for firearm charges. Yeah, Cameron Trimble is no stranger to the law. In fact, Channel 4 in Detroit says his criminal history dates back to 2013 in Michigan. Check this out. So 2013, he pleads guilty to felony unlawful driving away of an automobile and felony receiving and concealing a stolen motor vehicle, right? That's his first felony charge. Pleads guilty, 2 years probation. The next year, felony retail theft between $5,000 and $10,000. He pleads no contest. He gets 6 months in jail, followed by 3 years probation. January 6th, 2016, so we got 2 years. First degree felony retail fraud, no contest, 1 year in the Oakland County Jail. 2016, a week later actually, felony resisting and obstructing police, pleaded guilty, 1 year in the county jail to serve concurrently, by the way, with the charge that he had pleaded guilty to a week before, or pleaded no contest to, excuse me. December of 2016, so same year, felony theft out of Hamilton, Indiana, pleads guilty, 498 days in jail. Also so now we're up to 2018, February 2018, first degree felony retail fraud, pleads guilty, 18 months to 15 years in the Michigan Department of Corrections. March of last year, felony carrying a concealed weapon, felon in possession of a firearm, first degree felony stealing or retaining a financial transaction device for retail fraud, sentenced to 2 years probation. Now, I will say that, ordinarily and generally speaking, I am a believer that once you have done your time, you've served your sentence, and you have some of your rights restored, you should have all of your rights restored. I'm not a fan of this idea of, well, okay, you've served your time, you've gotten out of prison, now we'll let you vote, but we won't let you own a firearm. However, Cameron Trimble had not had his rights restored, and even though he had not been convicted of a violent crime, throughout his laundry list of histories, it looks like mostly it's retail fraud, obstructing police, felony theft, things of that nature. We're talking about multiple felonies here within the last decade. So I'm kind of surprised that just last year, when he was sentenced for being a felon illegally carrying a firearm, being a felon in possession of a firearm, as well as first-degree felony theft, that Cameron Trimble was sentenced to 2 years probation without any time behind bars whatsoever. Now, again, Trimble is still on active probation. In October of last year, Detroit police obtained a search warrant for his Instagram account, and they found a post from October the 10th in which Trimble had been streaming a live video and displayed at one point, well, actually at multiple points, a Glock pistol. First, it was on the passenger seat of the car that he was driving. And then he actually picked up the gun and showed it to the camera, saying, I got to keep my G-lock. Well, probably going to be hard to do that now from behind bars. But, Cameron Trimble, well known to authorities, well known to the courts, and should have known better than to brag on social media about his gun, given that he is not allowed by law to own one. Today's Armed Citizen story from Las Vegas, Nevada, where a burglar who was shot during a home invasion, also well known to law enforcement, and was considered a suspect in several other crimes. He's actually served time in prison for similar offenses in the past. 28-year-old Leroy Freeman faces 11 counts now of home invasion, 9 counts of residential burglary in what police call a crime spree across the Las Vegas Valley that started in November and did not end until just last week. Freeman served some time in prison for a series of home invasions back in 2017, according to police. He took a plea deal, and the judge in that case sentenced him to just 2 years behind bars, with a sentence ending in 2020. So we've got a little bit of our recidivist report at work here today as well. But Freeman was stopped during his last attempted home invasion, or alleged attempted home invasion, when an armed citizen, the homeowner whose house was being targeted, actually fired shots at a group of burglars who were breaking into his home. Freeman was injured. He was identified when he left his car, registered in his family name, in front of the crime scene. About an hour later, Freeman showed up at a local hospital with a gunshot wound that required surgery. Police determined that Freeman was a suspect in this burglary spree through phone records, videos, and because, again, he left a car there at the crime spree. After his arrest, police learned that Freeman was renting an apartment in Henderson, Nevada under a woman's name. Police say that Freeman stole her identity as well. They searched the apartment in early February, finding several stolen items as well as a firearm. He is currently being held on $250,000 bail. The homeowner who defended himself against that group of burglars, not facing any charges at all. And finally today, our good deed of the day. In the right place, at the right time, willing and able to do the right thing. In Vidor, Texas, the Vidor Police Department honoring 3 officers recently, Dakota Gaines, Brittany Haley, and a third officer, Sergeant Tom Meadows. These 3 officers helped to save the life of an individual who was having a heart attack a few days ago. And unfortunately, that individual did not survive, but he did live long enough that he could say goodbye to his family, that his family could say goodbye to him. This was back in December. Dakota Gaines was dispatched on a burglary call in front of a building. When she got there, she saw the man who had called in about the burglary walk out of a building on the property and then just collapse. She thought maybe he had just stumbled to the ground, but when she went over, she noticed that he wasn't really breathing right. He was unresponsive, so she began performing CPR. She alerted other officers that she needed help. And Sergeant Meadows, Officer Haley, excuse me, by the way, I did not mean to misgender Dakota Gaines, but Dakota Gaines is a he, not a she. So Officer Gaines then radioed for help, and other officers responded, including Officer Haley and Sergeant Meadows. The 3 of them performed CPR on the man until EMS crews arrived. Chief Rod Carroll says, as a police officer and a chief, I've heard many radio transmissions. I'm able to recognize the stress in an officer's voice when he's requesting assistance. And at this time, all available on-duty personnel just responded for help. So they were able to get this gentleman breathing again. They were able to get a pulse. They were able to get a heartbeat. He was taken to a local hospital. And as the Orange Leader in Vidor, Texas reports, that allowed him 8 more days to say goodbye to his loved ones. Chief Carroll says, as a man, I've lost families and friends over the years. He says the worst part of losing a loved one unexpectedly is that you cannot say goodbye. He says this leaves a void in us that must be overcome, but by the complainant surviving 8 more days, this allowed his family and friends not to remember Christmas as a time of sorrow in which they lost a loved one, but a time in which they had the opportunity to say goodbye. Officer Gaines, by the way, is no longer with the Vidor Police Department. Instead, he is now working for the police department in Beaumont, Texas. But regardless of where he is serving now, we thank him, as well as Officer Haley and Sergeant Meadows, for their very, very good deed. That is going to do it for this edition of Bearing Arms Cam and Company. I want to thank you for being a part of the program as always. We love having you here. Hope you'll check out bearingarms.com throughout the day for even more of the latest Second Amendment news and information that you need to know about. We'll be back with another edition of Cam and Company on Monday. But again, check out the website throughout the day, of course, throughout the weekend as well, and we'll keep you up to date on everything you need to know about what's going on in the fight to keep your Second Amendment rights safe and secure. If you like what you see, you can always become a VIP subscriber. All you have to do is go to bearingarms.com/subscribe, use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. We'll not only be thanking you for showing your support for our independent pro-Second Amendment journalism, but we'll offer you exclusive content, analysis, news story, stuff you won't find anywhere else, because, again, your support really does make a difference, and it matters to us. So thank you again. Until we talk again, be well, be safe, and be free.